Imagine losing your child to murder, sitting through the trial, watching the judge deliver a sentence that feels like a slap in the face, and then being told you have 28 days to challenge it. 28 days, while you're still identifying the clothes they were buried in. Welcome back to British Reform, and today we're talking about a reform that is long overdue, genuinely important, and, brace yourself, actually something the government has got right. The Unduly Lenient Sentence Scheme has existed for years, and most people have absolutely no idea it exists. In theory, it's a brilliant safeguard. If a Crown Court hands down a sentence that seems absurdly light for the crime, any member of the public can ask the Attorney General to refer it to the Court of Appeal for review. A tool to hold the judiciary accountable. A mechanism so victims don't just have to swallow whatever punishment, or lack of it, gets handed down. In practice, it's been a bureaucratic obstacle course dressed up as a victim's right. And today, finally, that is starting to change. So here's the story. The government has confirmed, as part of the Victims in Courts Bill, that victims and bereaved families will now have up to 6 months to request a sentence review under the Unduly Lenient Sentence Scheme, up from the previous limit of just 28 days. And alongside that, there will be a new statutory duty to notify victims that the scheme even exists. That second part is arguably just as important as the first, and here's why. Because here's the thing about that 28-day window. The system wasn't just short, it was secretive. Victims weren't automatically told the scheme existed. The responsibility for informing them sat with witness care units, which, given the sheer scale of cases moving through the criminal justice system and the chronic underfunding of those units, meant that awareness was patchy at best and non-existent at worst. You could be a bereaved parent who sat through a murder trial, watched a judge hand down a sentence you felt was an insult to your loved one's memory, and simply never be told you had any right to challenge it at all. And then if you found out on day 27, you had exactly 1 day to lodge a formal legal application while grieving. That isn't justice. That's an administrative trap. The human cost of this system is not abstract. Take Tracey Hanson, who lost her son Josh to a horrific murder and spent 7 years campaigning for this exact change through the Josh Hanson Trust. When it came to challenging the sentence handed to his killer, Tracey was only made aware of the scheme on the 28th day itself, the final day of the window, through a conversation with Claire Waxman, then London's Victims Commissioner. She submitted her application the same day. It was rejected for being outside court hours. There was no mention of court hours anywhere in the Victims Code or on the government website at the time. 7 years of relentless campaigning just to be told, sorry, you were technically a few hours too late on the 1 day you found out you had rights. In any other walk of life, that would be a scandal. In the British justice system, it was just Thursday. And Tracey wasn't alone. Katie Brett, whose loved one was also taken through murder, was another voice behind this campaign. There's Sasha's family, a 16-year-old girl murdered, her family given 28 days to appeal the sentence, not notified until it was too late. Their quote is worth understanding. No family should ever be left in the dark like we were. Every victim deserves support. These aren't abstract policy arguments. These are people whose lives were destroyed twice, once by the crime, and once by a system that was supposed to protect them but instead handed them a ticking clock and forgot to tell them it was running. Now let's be clear about what the scheme actually is and how it works. Because context matters here. For a sentence to be unduly lenient, it doesn't just have to be light. It has to fall outside the reasonable range of sentences a judge could have given, taking all factors into account. This isn't a mechanism for victims to simply relitigate sentences they didn't like. The Court of Appeal doesn't increase a sentence just because someone is upset. The bar is genuinely high, which actually makes the argument for extending the time limit even stronger. Because if the threshold is that demanding, victims need time to understand it, seek legal advice, and make a properly informed application. 28 days was never fit for purpose. 6 months is closer to what the situation actually demands. But, and this is important, members of the general public who are not the direct victim or bereaved family will still only have 28 days. The extended window is specifically for those most closely affected by the crime. And there will be operational guidance published setting out what in the interests of justice means when the Attorney General is deciding whether to refer a case. So this isn't a free-for-all. There are still gatekeepers. The system still has rigor. It's just no longer designed to accidentally exclude the very people it was supposed to save. Now let's talk about the bigger picture, because this reform doesn't exist in a vacuum. The Victims in Courts Bill is one of the most substantive pieces of criminal justice legislation in years. It also includes measures to compel offenders to attend their own sentencing hearings, because apparently that needed to be made compulsory, which tells you quite a lot about the state of things. It restricts parental responsibility for certain sex offenders. It enhances the powers of the Victims Commissioner. And it comes alongside the government's broader courts reform agenda, which is trying to grapple with a Crown Court backlog that, without structural change, is projected to hit 130,000 cases by 2030 and 200,000 by 2035. That is not a backlog. That is a queue that has given up and sat down. The Shadow Justice Minister Dr Kieran Mullan acknowledged that extending the time limit is a good step, while also making the pointed observation that Labour had spent months voting down sensible proposals for reform before arriving at this position. And that tension is worth holding on to. Credit where it's due. This is a genuine improvement, long campaigned for, and meaningfully overdue. But the history of how it got here, the years victims spent being told the system couldn't change, the procedural votes against reforms that Parliament eventually adopted anyway, none of that should be quietly airbrushed out. Because the justice system in this country has, for too long, functioned in ways that are easier to navigate if you're a defendant with legal representation than if you're a victim without it. Offenders are told at their post-sentence meeting that they have the right to appeal. Victims weren't even guaranteed to be told the Unduly Lenient Sentence Scheme existed. That asymmetry was baked into the system, not by malice necessarily, but by decades of incremental legislation that kept adding rights for one side of the courtroom while leaving the other to work things out for themselves. Today's change chips away at that imbalance. It doesn't fix everything. There are still 100 things wrong with the British justice system. The backlog, the underfunding of the Crown Prosecution Service, the treatment of rape victims in court, the postcode lottery of sentencing, the creaking probation service. But you fix a broken system one real reform at a time. And this is a real reform. Tracey Hanson's 7-year campaign has achieved something lasting. Josh's name is attached to a change in the law that will give future victims something his mother was almost denied: time, knowledge, and a genuine opportunity to be heard. That matters. That is what justice is supposed to feel like. And if you want to keep across every development in UK politics, the wins, the failures, the things Westminster would rather you didn't notice, you know what to do. Subscribe to British Reform. Drop a comment below on what you make of today's changes, and we will see you in the next one.